I'm Cassandra Hearn, a top divorce litigator in California. I have a passion for educating you through your own divorce process. I've taken the toughest of divorce cases to trial, including everything from divorces worth millions of dollars to serious child abuse cases to cases where spouses have turned to wage war against each other. Over the past 15 years of litigation experience, I have seen all of the highs and lows that come with making your way through a divorce. I created this podcast to help you gain insight and get into the right mindset so you can do a divorce by yourself and to help you make all the right decisions along the way. Whether you're just thinking about divorce or are right in the middle of one, if you're looking for information, tools, inspiration, and a community to help you through it, you're in the right place. Welcome to the podcast, where I will be sharing with you all of my divorce secrets. Today we'll talk about understanding divorce attorney's fees. And what I'm really saying to you is I'm going to give you the real deal on what to expect with attorney's fees. Keep in mind that in California, most people who are going through a divorce never use an attorney. In fact, about 70% of people who get a divorce are not going to use one at all. So for the 30% of you who are out there and are either using an attorney or are contemplating using an attorney, this one's for you. Or if you're just curious and you are representing yourself, but you're thinking, maybe I do need the help of a lawyer, take a listen because I'm going to break down the real deal on attorney's fees. First, let's talk about how attorney's fees work broadly in a divorce case. There are two types, typically, of fees. The first is an hourly attorney fee, and the second is an attorney fee based on a flat rate. Those fees are less frequently used. Most attorneys default to using an hourly rate, but occasionally you'll find an attorney who's willing to do some kind of limited service on just a flat rate. So let's keep both of those options in mind as we go forward, but I'm going to spend the majority of the time today on hourly attorney's fees because they're just so much more common. So, what can you expect if you're looking for an attorney to represent you in your divorce on an hourly basis? First, let's talk about rates. Most attorneys in the state of California are going to be charging at the very least somewhere around $150 or $200, and at the very most in the most populated, heavy, big city areas with celebrities who are divorcing and whatnot, you can see attorney's fees going up to $1,000 per hour. That's a huge range. $150 to $1,000, that sounds crazy. Well, what's the average? Across all counties across the state of California, the average rate is still a rate band. So the average is somewhere around $300 to $500 per hour at the bottom and top of the average rate. Now, I'm going to say something that may not be a popular opinion, but it is true. And it's true based on my many years working as a divorce attorney. When a client or a person goes to an attorney and says, hey, how much do you charge? I'd like to consult with you for potentially representing me in my divorce case. The attorney could say something like, oh, I charge $300 an hour. And the client will nod and say, okay. And in their mind, they're thinking $300. They're not thinking $15,000 or $20,000 or more. So there's a big disconnect between a person saying, how much does your attorney charge per hour versus a true understanding of what those hours will ultimately cost you. We're going to talk in a moment about how those numbers add up and what types of things make the attorney's fees so expensive. Let's say, for example, you decided to go forward with the attorney who's willing to charge you $300 an hour. One thing you should keep in mind is that the attorney doesn't just bill in hourly blocks. The attorney is going to be billing either by the minute or by an hour increment. And that's really important to know when you're asking your attorney about how the billing works. Most attorneys will default in family court to a pretty low hourly increment. Well, what does hourly increment even mean? Most attorneys will bill at a minimum at 6-minute increments. This means that your hour with your attorney at $300 an hour is divided up 10 times. 10 times 6 is 60. So when you see a bill from your attorney, you will see increments of an hour on each bill. For example, if I spoke with a client and I was charging $300 an hour, I might have spoken with that client for 1 hour and 5 minutes. In the billing, you will see that the client gets charged for 1 hour and 6 minutes. This is because that additional minute gets rounded up to the nearest increment. You should also know that most attorneys will also have language in their fee agreements that say it is in the attorney's discretion whether to round up to the nearest increment or to round down. So, for example, if it was 1 hour and 5 minutes, I could choose as the attorney to round down to just 1 hour if I felt like it. I'll tell you, in most cases, most attorneys feel like rounding up. Now, 6 minutes is the lowest, typically, and most cost-effective method for attorney time billing. However, it's not the only method. Many attorneys will break up the hour to their benefit. So, for example, instead of billing in 6-minute increments, they'll bill in 12-minute increments, 15, 20, or even higher. So, for example, that 1 hour and 5-minute phone call, if you're working with an attorney who bills in 20-minute increments, would be charged at the attorney's discretion for 1 hour and 20 minutes instead of 1 hour and 5 minutes. This is something that nobody really talks about, but I'm happy to share with you as you're thinking about whether or not you would like to retain an attorney to help you with your divorce. Let's also talk about something else that happens frequently with attorney billing, and that is what's called an evergreen accounting. What that means is that if you pay your attorney, for example, $5,000 to start working on the case, the attorney starts working on your case, and after the first month is done, let's just say the attorney's billed $2,500 for work that was completed on the case. Well, with an evergreen account, you will have to see your bill and say, oh, look, my attorney billed me $2,500. Good thing I have another $2,500 in my account. However, if the attorney's fee agreement says that you need to keep your account evergreen with a rate of $5,000, even though you've only spent $2,500 and you've got $2,500 on your account with your attorney, you're going to have to add another $2,500 at the end of that first month to keep your account at the rate of $5,000 evergreen. This is to protect the attorney so that the attorney does not end up working for you for free. In a divorce case, it can be really unpredictable as to how much money a case or an account will charge each month. For example, you might start the month thinking, oh great, all we have to do this month is show up for this one hearing. But in the meantime, unbeknownst to everyone, the other side throws a fit over something or demands something that wasn't expected, and all of a sudden, the month turns into not just one motion hearing, but several. Maybe an ex parte hearing, maybe discovery is issued, maybe other motions are filed. You just don't know. And the attorney is going to call you and say, uh-oh, you've got some extra legal work on your case this month, and that 5,000 is just gone. So not only do you need to renew the 5,000 at the end of the month, but if you want to get through this, you're going to have to pay an extra fill in the blank on how many dollars the attorney thinks it's going to cost. So when you're thinking about a divorce case and how much can I afford, if you're saying to yourself, well, the total amount of money I could ever scrape up from anywhere, including credit cards, cash, checks, borrowed money, what have you, if the total amount of money you have is just one rate, then you should be shopping for a flat rate attorney and not an attorney who can and will bill you hourly and expect you at the end of each month to pay up. People oftentimes wonder if it's possible to help reduce the attorney's fees in their case by paying for an attorney who utilizes a paralegal or just a paralegal as a whole. One word of caution is that paralegals are not attorneys. I repeat, they are not attorneys. It is called paralegal for a reason. It is not an attorney or a lawyer who would be helping you. So if you're going to hire someone who's just a paralegal, and I don't mean just, being a paralegal is great, but they're not able to advise you like an attorney would. So the paralegals cannot say to you, here's a good piece of advice, or you should do the following. They simply can't. So keep that in mind if you're looking for just that. What if you're looking for an attorney who utilizes a paralegal at their firm to try to help reduce costs? Well, my experience has been that paralegals who work in the family law setting oftentimes cause additional charges on the case. Not always. Certainly there are paralegals who are worth their weight in gold. Oftentimes they're communicating with you, the client, and then they're putting that information they receive from you into court forms or into court pleading paperwork. But then we're also seeing billing time for not just the paralegal, but the paralegal and then the reviewing attorney. And the reviewing attorney could be an associate, or it could be the primary attorney on your case. And then you have potentially 2 or even 3 charges on your case for one line item of work. I'll give you an example. Let's say paralegal contacts you from the law firm you hired to say, we need to fill out your financial forms. Can you give me your pay stubs and all of your information regarding your monthly expenses and your earnings? So you provide the paralegal all of that information. Then the paralegal puts all that magic information into the court forms. That's one charge. And then hands those court forms to the associate who's working on your case, who's now going to look at what you originally provided and then also look at what the paralegal did, and then they may either make some changes or say, okay, we're good. Now, the buck could stop there, or maybe not. Sometimes the associate will say, no, go back to the paralegal, this isn't correct, change some of this information or revise this. Now you've got a charge for the original work by the paralegal, a charge by the reviewing associate attorney, and a new charge for the paralegal to go back and fix the paperwork. Then it goes back to that associate attorney for another review to make sure it is correct, because the paralegal cannot give legal advice and cannot make legal decisions for you. So you're really paying 2 people to do one task back and forth over and over again. And there's even yet a third possible charge in there. What if we have the same scenario where the paralegal gave the draft to the associate, but the associate is a newer or a younger attorney? In most cases, this is true. So the associate is not sure if the work is correct and wants the senior attorney on your case to help give more insight or more depth about how a certain issue should be handled on your finances. You guessed it. Now you've got a charge from the paralegal, a charge from the associate to review, and an upcharge for the senior attorney to review and either kick it all the way back down the line for the paralegal to finish up and edit and then start all over again, or if you're lucky, it's done. In any case, you can imagine that these fees for the attorney's fees and the paralegal fees add up very quickly. We live in a day and age now where most attorneys are extremely adept at handling court forms and word processing documents and PDFs. And so, if you went to an attorney to say, I'm considering hiring an attorney, I want to know how the fees work. Do you use a paralegal? And if so, what for? If you want to avoid this situation where you have this chain of expenses going all the way from the paralegal up to the senior attorney, ask the attorney, are you going to fill out my court forms for me? Or do I fill them out and send them to you? Because I don't want to pay for 2 or more people to do the same task. Now, when we're talking about attorneys' fees billed on an hourly basis, no conversation about this would be complete without also discussing the costs associated with attorney travel time and attorney wait time. In family court, it's really common to wait. So lots of courthouses across the state now offer the option for attorneys and their clients to appear virtually for most types of hearings. Not really for trial, not really for contested hearings, but for things like status conferences or short motion hearings or chickens with the court. So you can ask your attorney if it's possible to appear virtually for most of the hearings in your case to save you on attorney travel time. I mean, traveling back and forth to the courthouse, parking, whatnot. In most cases, you can save a lot of money by asking for this. However, keep in mind that there is waiting time for attorneys, even if you're appearing virtually. I'll give you an example. Let's say your hearing is set for 9 a.m., but the calendar for the judge goes until noon. You could be called very first on the court's calendar and be done by 9:05 a.m. Or, luck of the draw, you may be called last, and that could be closer to noon. In either case, you're going to be paying your attorney for their hourly rate to sit there and wait with you, whether it's virtually or in person, from 9 a.m. until your case is called and done. So you can't just assume that you've got a 20-minute or a 40-minute hearing that's scheduled, and so you'll pay for 20 minutes. No, you're probably going to be paying for about 3 hours of time on an average court hearing calendar. So attorney travel time to and from court and attorney wait time is incredibly common and something that most people don't think about when they say, well, I got my lawyer for the great discounted price of $300 per hour. I mentioned at the beginning, there's also the option for a flat rate attorney. This is a special kind of arrangement where your attorney is only doing something limited for you. What this means is that the attorney is going to assist you with a task. It usually does not mean the attorney is going to come in on your case as a whole and represent you as a whole for a flat rate, although it's possible. Very uncommon to see that. If you can imagine, family court is extremely unpredictable. Attorneys don't know everything that's going to happen to you during your case, but they can make some good estimates. Where do we see flat rates? We can see flat rate attorney's fees for things like, I'll just help you file your paperwork. I'm going to draft it for you. You'll put your name on it. We'll get it sent down to court and boom, it's filed. Pay me the flat rate of X dollars to get this done. Or, no, I won't substitute in for you on your case, but I will appear just at your hearing. So pay me the flat rate of fill in the blank, X, for prepping for the hearing and just appearing on that one day of your hearing. This is also called a limited scope representation. Limited scope representation can also be hourly too, though, so it may be something that's available to you in either direction depending on what you're looking for. The limited scope means the attorney is not going to be there for you for everything. They're only going to be there for you for what you paid for. And you have to make this arrangement in advance with your attorney that you're interviewing. So if you're going to be going to a consultation or you're calling attorneys to try to find someone to help you and you have a limited budget, you can ask if the attorney will do any work on a limited scope basis. This is not a very popular option and few attorneys offer it, but they do. So if you're interested and you're looking, you should definitely ask that question if that's something you think you would need. Let's talk about some of the services that attorneys usually offer for their clients so you understand what you're actually hiring the person for. In a divorce case, typical services will include drafting. That's writing your court paperwork for you, checking all the right boxes, making legal arguments for you in your written documents to the court, and getting them in and getting them done for you. Other services also include strategy. This is where you're hiring the attorney to talk you through your case and figure out what pivotal decisions you will make that will benefit you in your case. There's also, of course, just advice. That's a little different than strategy because an attorney giving just advice will say, hey, tell me what your issues are. You'll tell the issues, and then the attorney will say, when this comes up, I would advise you that the law says this, and you can have the following choices based on what the law says. Other services that attorneys offer include negotiations. This can be case negotiations, individual issue negotiations, and working together to try to reach a settlement or a resolution in your case. Of course, attorneys' fees also go towards things like representing you in court, not just drafting and getting paperwork done, fighting for you at motion hearings, and fighting for you at trial. Attorneys' fees can also include things like mediation. You may want an attorney to prepare you for mediation, figure out your bottom line in advance, and attend the mediation with you to make sure you get the best possible deal. Attorney's fees will also include other tasks on your case too, and that's things like discovery, typical motion work, exploring information, finding evidence, and presenting that evidence on your behalf to the court. You may be wondering to yourself, how can I get an attorney but keep my costs low? We're going to talk about that next week. So this week is all about understanding the fees and where in the world they come from. But in the meantime, I do want to share with you a few tips about understanding attorney's fees in your case before you speak with an attorney. So, what kinds of questions should you be aware of and asking your prospective attorney that you might want to work with? Of course, we have the typical questions, right? You want to ask about their experience level. You want to tell them about your case and have them relate back to you other cases they may have worked on that are similar in either issues or principles. And you also want to speak with them from your heart. You want to tell them the real truth about what's going on in your case and get a real feel for how you connect with them. So much of working with an attorney is trust. You're giving your precious legal position to someone else to guard and to hold. You want to make sure that the attorney you meet with connects with you on a real basis and that you have confidence in this person. You have to follow your gut for this. There's no magic checklist. There's no special way to know. You have to trust yourself and you have to trust that attorney when you decide if you are going to hire them. If you're not sure, that's your answer. Ultimately, if you decide to work with an attorney, you have to feel comfortable that the attorney is going to do the best job for you and that the attorney is going to make the best use of your hard-earned fees. Tune in next time where we'll talk about how to keep your fees low and things that you can do to be resourceful in your own case. See you next time.